Thank you. Thank you, Victoria. Good afternoon, everyone. Good to see you all again. I just want to kind of piggyback on that last presentation and say that if you are a builder, if you are a storyteller, if you are a disruptor, a weaver, a frontliner, then this panel is absolutely for you because it kind of incorporates all these ideas of the change ecosystem. So thank you for that wonderful presentation before that, because it really lays out our foundation for how we can use litigation. So we know litigation is certainly not the path of least resistance. It absolutely takes courage to take on this kind of workload. Our hope today is that this panel will educate you all, whether you're social, whether you're legal advocates, and just a general background on litigation, just to build up that competency so you can kind of understand and keep an eye out for potential litigation issues and see it as a possibility to a solution when it comes to the child's immigration case. After all, litigation is in many ways an exercise in creativity to improve our laws and our immigration system. We have to imagine a better reality and search out clients, classes, and creative arguments to support that vision. And I believe that our first panel really laid out some of that foundation. The truth is that in the last 7 years, we've witnessed the true volatility of this immigration system. Norms are not guaranteed. It can really be changed by a memo, a policy, a regulation change, depending who's in power, not just at a presidential level, but at the head of USCIS office. And what can be a way to foster protection for children can quickly be changed into a way to directly victimize them. For this reason, when this system fails these children, we have to be critical, we have to document, we have to elevate these issues in order to obtain permanent systematic change, or at the very least, get a reprieve from the unjust policy that's being applied to these kids. I know not that long ago, we were all seeing family separation, sponsor rates for the kids that were in ORR custody. That information was being shared with ICE, and ICE was going to these sponsors' homes to detain these sponsors. We saw unaccompanied immigrant children subjected to MPP, the Remain in Mexico program. We saw termination of DACA, the automatic detention of children on their 18th birthday instead of being released from ORR custody. Now we're seeing delays in the adjudicatum of asylum and SIJS. We're also seeing delays in adjustment. We have these arbitrary caps on SIJS, U visas, and we're starting to see that the trafficking visa is heading in that same exact pathway. So with that foundation, I kind of wanted to open it up to our panel and kind of ask them, from their perspective, from their experience, what role can litigation play in defending these children from these threats?
I can kick us off. Thanks so much, Deanna. So I spent many years representing unaccompanied children, doing direct services at NIJC in Chicago, and I absolutely loved that work. But what motivated me to start litigating was representing clients during the Trump administration and seeing how unlawful policies were affecting them firsthand, and also feeling powerless to do anything. And I would keep appealing to the AAO or looking for other creative solutions, but I felt like I was hitting a wall, really similar to what you mentioned in your introduction. So litigation can be such a useful tool to help in individual cases when you've hit this agency wall and maybe the agency just isn't following the law, or also in situations where a broader policy is being applied, not just to your client, but to many other children. So through class actions and multi-plaintiff litigation, change can also be made on a broader scale so that maybe this unlawful policy or regulation can be declared unlawful and it can't harm other children going forward. So I know litigation can be intimidating when you don't know where to start or how the process works. So we're really hoping to shed some light on the process through this presentation today.
Yvette, if you don't mind sharing with us about your perspective.
I think it's similar to Gianna. I was an immigration attorney practitioner for 5.5 years. And really, it was brutal under the Trump administration, right? Figuring out, as you said, like finding out what creative arguments can we push through, right? Because our way of practicing had to completely change, right? We had to be more aggressive. We had to start filing several briefs, right, in immigration court. And so really it's eventually, I felt like I hit a dead end and wanted to figure out what other ways can I help push forward these arguments that we were trying to make. Also figure out how to shed light, right, to the system, figure out ways of, and I remember, as an immigration practitioner really relying on the SIJ policy manual, right? And eventually learned how that, that came about, right? It was through a a policy FOIA request, right? And so it really just put things into perspective of how these two worlds really work together and, the importance of the collaboration.
Gardner, you and I are wearing similar roles here as the immigration attorneys on the ground, while Yvette and Gianna are kind of giving us our litigator perspective. But if you could share with us kind of what litigation kind of means to you in defending the immigration case for the child.
Yeah, now that I've been doing direct services for just over a year now, my previous experience was as a fellow working with the children's program and the litigation unit here at Raíces. But now that I've been working with my own clients for a while, a lot of the motivation I have to think about litigation is thinking about my future clients, right? I mean, we love and respect our current clients, and we should show the same love and respect for our future clients. And I think one of the ways to do that is to think about how we can change the system through litigation, or, as has been previously discussed today, through advocacy for legislation. But this is just another tool I think that we have to use because working with not only with immigrants, but immigrant children, they're just up against this compound vulnerability, right? You have a system that's just not set up to help, foster good outcomes. You have language barriers and bureaucracy, and then to face that as a child is just an extra compound vulnerability, and the system is going to fail, right? That's why we put it in the title. It's inevitable, especially for kids. So I think we're in a unique place where we really should be considering all of the tools in our toolkit, and litigation is one of them. And yeah, think about your future clients, because you might be able to save them from an issue that would derail their case if you can get creative and litigate something that's facing your current clients.
You brought up your fellowship, which I'm glad you did, because in your fellowship, you kind of had to research and understand some of the different litigation avenues that were available in different immigration spheres. Could you help us get a bit of the basics of what these litigation avenues are, and try and bring in the perspective of, if you're the immigration attorney, what are things you should be looking for to understand, like old school law school issue spotting?
Yeah, for sure. This could be the beginnings of a syllabus for like Fed courts for immigration for a law school class someday. But what I'm going to do here is just quickly touch on each of these litigation avenues, what the sort of purpose is, or just the basics, and then a few examples, just to refresh us all on what possibilities are out there, instead of just saying, oh, litigate something. We want to give y'all some ideas about what you could do. So starting with class action suits, y'all are familiar with this. This is litigation for multiple plaintiffs, groups of plaintiffs, and often aimed at impact litigation, right? Trying to change the law by showing how it's negatively impacting swaths of clients. A couple examples, think about the Miss L versus ICE litigation led by the ACLU, which was the response to the Trump administration's zero tolerance family separation policy. I like to think of this one too as a good example of working within settlement agreements. A lot of times you think litigation and you think, oh, we're going to go have our day in court and we're going to win and it's going to be great. But oftentimes it's settlement negotiations, right? And you think about the Flores settlement agreement as well, and how decades of working within a settlement agreement has helped to improve detention conditions. So that's one thing to keep in mind also as you're litigating, is what could be done within the parameters of settlement agreements and negotiations. JOP versus DHS also, this is one where TVPRA rights of UCs who were seeking asylum were being violated once these kids turned 18, and a class was put together, and those rights were protected. So let's go to mandamus and the Administrative Procedure Act. We lump those two together because they both can deal with remedying delay, but I don't want us to think about them only in terms of delay, because the Administrative Procedure Act is really basically there to just make sure that agencies are following their rules and regulations and policies. But mandamus, you'd want to think of something where the client has a clear right to adjudication. So that's oftentimes things that you're sending to USCIS, not necessarily asylum, unfortunately, but other USCIS applications. And then, yeah, with agency action, the language is agency action that's unlawfully withheld or unreasonably delayed. But again, don't think of it just in terms of delay as in those cases that have been in limbo for a long time. For example, we're going to talk about a case later on called ImmDef v. DHS. And the APA claims there include failure by ICE, or are centered on the following things, such as failure by ICE to issue TVPRA NTAs, or USCIS's failure to exercise jurisdiction over I-589 applications for UCs. So that's an idea of mandamus in the APA and what you can do with those. Temporary restraining orders, I think a lot of people are familiar with just from the news, right? These are emergency measures to keep bad policies or bad decisions from going into effect. Like when the Trump administration issued the Muslim ban, right? Of course, people were quick to file TROs, trying to maintain the status quo. You can also file a TRO in addition, or like with your petition for review when you're challenging removal at the BIA, from the BIA to the circuit court. So PFRs, the petitions for review, like I just mentioned, is when you're appealing something from the BIA to the circuit court. And this is one where you're wanting to think about what's the right case that could get us to overturn some bad precedent. Think about Sessions v. DiMaia, which is that crimmigration case that eventually went to the Supreme Court about crime of violence under the NTA being unconstitutionally vague. There's Nice Chavez, which are the kind of the NTA family of cases for deficient NTAs. Habeas, this is where we're looking to challenge physical detention and other restrictions on liberty. It's not something you can use to challenge removal per se. It's more about people being detained for too long. Importantly, for those of us here at CELA who work with kids, use habeas to challenge minors being detained in adult detention. And there's also post-removal order detention, which puts you in Zadvidas land. That's the Supreme Court case that governs there. Okay, the Federal Tort Claims Act. This one's not necessarily immigration relief oriented, but it allows you to sue the federal government for tort damages if you can show that another actor or another defendant would be liable under state tort law. It starts with an administrative complaint called the SF-95. So it's kind of, it feels like two suits in one almost. Then Yvette hinted at FOIA and transparency litigation, and how you can do this on an individual level if you need the documents and all the things that have been filed in your client's I-589, for example, whether there was a declaration filed with it or not, so that you can figure out if there are credibility issues. And if you get a FOIA denial, there are lots of resources out there and people who can help you challenge a denial or a partial denial. But you can also think about transparency litigation on the impact level, right? Like Yvette was hinting at with the SIJS policy manual, or other policies, memos, things that necessarily aren't available to the public but should be, right? Things we want to know about how the government and its agencies are operating. And then civil rights claims. I threw these in here even though they're difficult to win, increasingly so, but they're worth considering. So under Section 1983 and under Bivens, you can consider litigating the government's violations of our clients' civil rights. So sorry, that was a lot of fast talk about the Fed courts aspects of this, and but hopefully it lays a little bit of a foundation.
No, we appreciate Gardner, and I want to dive into some of these avenues, if you will. So you had initially helped us, us being RICEs, develop a system of identifying when some patterns could be elevated, or when we're spotting some issues that might be worthy of litigation or elevating to a litigation team. Share with us how you did it. So how did you identify a pattern? And what's a good way for us on the front lines to think about litigation when doing this direct work?
Yeah, happy to. So for context, my fellowship, the goal of my fellowship essentially was to make sure that all of our children's program clients were getting the access that they deserved to our internal team of federal litigators. And these same principles can apply even if you don't have internal litigators. Essentially, I guess it sort of developed over time. At first, when I started the fellowship, I was kind of the system. Like I was just a point person because I was just telling people, hey, if you want to talk to litigation, let me know and I'll help you coordinate with them. And so it started out that way while I was getting my feet under me. But then as I started to make it to more meetings and things like that, we established some patterns. Raíces was employing something and is now again called attorney roundtables, where we were getting together and just putting our heads together as legal teams and saying, what issues are we facing? What obstacles are frustrating us? And then we started to identify patterns, right? And then you take those patterns and you check them against your colleagues' work at other organizations, right? Like get involved with the listservs or the coalitions, SIJS Backlog Coalition, or DHS accountability calls, things like that, or stakeholder meetings, right, where you can see what other issues other practitioners are bringing up. And then we found it really important to start centralizing and tracking everything. We created some spreadsheets, for example, that are accessible by everyone in our program to track. For example, we had one spreadsheet tracking long adjustment of status adjudication delays. And so we had a spreadsheet, and we actually have included this one in our materials, sort of a template of it that tracks like, okay, who's in charge of this case? What has already happened in this case? When were things filed? When were receipt numbers given? And which inquiries have been made? What questions do we have, and what are the next steps? So tracking that all, and then being able to see, oh, okay, we have 12 or 13 adjustment of status adjudications that have been delayed more than 3 years. What's going on? What are the patterns? When you have them all in one central place, you can identify patterns and then prioritize which ones really need to be elevated up to the litigators, or which ones might be a fluke, or which ones maybe our team hasn't, done all of our administrative exhaustion steps, so to speak. So those are some of the things that we found successful in sort of sussing these out. But I really like what you have at the top, Deanna, gut check. And I sometimes would call it the smell test. If something smells fishy, you just gotta look into it and gotta ask. And sometimes, it won't lead to something big in terms of litigation, but it might, and it's worth elevating it up and discussing it with your supervisor, or, bringing it to an internal or an external team of litigators to at least think it through and have a look.
Yeah, I think one of the things I've really appreciated in working with Yvette, Gianna, and you, Gardner, is that as we're trying to exhaust this immigration system, is we're trying to understand why this is happening. Is it reflective of a policy? Is it just an arbitrary decision? And that's kind of what helps us get to the bigger problems that might be litigation worthy. You talked about the adjustment of status issue, and I know that you and I have also been working on the asylum backlog, trying to figure out whether or not these issues are ripe to refer the case to a litigator. Can you kind of share a little bit about this? How do you document or how do you work to get something ripe before you refer it to litigation?
I think one of the takeaways from my fellowship, and Yvette was one of my litigation supervisors, and so basically, to quote Yvette, it was like, have we prepared the record? Like, is there a good record? And maybe you can speak to this a little more, Yvette, that you have a little more experience, but going back to the just really good documentation and, being able to track what has been done, I think can help you make sure that it is a well-prepared record. Have you exhausted administrative exhaustion requirements, etc.? But Yvette, maybe you could speak to this one too.
Yes, I think, as you said, it's preparing the record, setting the record. And what that means is really, I mean, I want to make sure that you all understand, you all are the experts in in immigration law, right? So you know if there's something smells funny, it's because you probably know the law, you know the policy, you know they're violating something, right? This does not match up to what the law says or the policy states, right? And so it's really, empowering yourself with, sending emails, asking, questions to your stakeholders, right? Again, you guys are the expert in this field. You know who you have to contact if a minor's in detention, all the juvenile field office coordinator, right? All the or people who you can contact, but also outside, right? The ombudsman's office. And so it's really creating a record citing to the policy that you believe, it isn't being followed. And really, I think as litigators, what we want to be able to tell the judge is say, look, we tried everything that we could to avoid filing this lawsuit, and just show exactly how the government continued to fail through our various requests, our various, and I do want to say it's better if it's in writing. And so, yeah, just make sure to cite what policy or regulation you're relying on.
Yvette, I kind of hear you reflecting a little bit of the things we did in ImmDef versus DHS. So let's talk about that. And then Gianna, I want to talk about a case you and I worked on. So Yvette, with ImmDef versus DHS, I know you were key and essential in helping us kind of document and exhaust that record. So tell us a little bit about what is ImmDef versus DHS, if you could just set the scene, and then we'll get into the different steps we took on the ground to kind of exhaust and document.
Yes, so ImmDef v. DHS is a suit, that was filed by Raíces and a group of immigration rights organizations representing unaccompanied children. We filed a complaint for declaratory and injunctive relief against the U.S. government for denying unaccompanied children previously subjected to MPP program their congressional mandated protections under the TVPRA. And so basically it's children that were previously, in MPP proceedings with their parent, and for whatever reason, they ended up back in the United States, and, in a detention, and I guess they were treated as unaccompanied children now, but they were somehow still being, either treated, or being subjected to either an MPP removal order or an MPP immigration proceeding.
And you talked about a letter to the FOJC. So we basically all of a sudden started getting notice from the FOJCs. These kids are being removed from ORR custody. They have prior removal orders. In some situations, we hadn't even had an opportunity to do an intake. So in consulting with you all, the recommendation was send an email demanding that these children be placed in TVPRA 240 removal proceedings. Basically, they can't be subjected to the previous removal order. They are now UICs. The TVPRA says you shall be placed in removal proceedings. And that email was critical, because the way they responded to or didn't respond to that email ended up showing the why. What was happening? Is this a policy in place or not? And then from there, we kind of had to exhaust our legal remedies, right? So our detention teams had to write up the motions to reopen, the stays, file for applications for relief, sometimes in a matter of days, and go all the way through the system and the agency response and calling the FOJC, doing notes about those calls, doing email repeat backs of those calls. That was really critical. Can you tell us a little bit more about what that looked like on the ground, to help our team understand, like, what does documenting even mean? How can I catch admissions, if you will, through the course of the immigration representation?
Yeah, so I think in practice, what I was hearing from our team was that, they had just gotten a minor in detention, and all of a sudden, this minor was going to be removed, right? So a lot of the record, building had to be, we had to send out emails asking, questions about, the reason why they were being removed, asking, the government if they can provide us, either the transcript of the MPP proceeding, or they can provide us even the removal order. A lot of times, our immigration practitioners didn't even have the removal order to base, their motion to reopen, their motion to reconsider. And so some of the groundwork was having to request information, and see if that information is, available to you. Oftentimes it wasn't. So, a lot of our immigration attorneys had to submit, motions and appeals that, really, they were very limited because, they had very little knowledge. As as many of you know, these are children. A lot of children didn't know what was happening, when they were with their parents, right? Their parents were handling the MPP proceedings. So they were really unaware of like what actually had happened in their MPP proceeding. And so part of it was, trying to request information, right? But obviously got rejected. And then, once, filing motions, ensuring that we definitely included arguments, like due process arguments there. I think, Diana and I definitely, talked a lot about what kind of arguments, without knowing anything, right, about this client. What are the arguments that we for sure can foresee, this chaos, what arguments could apply to this chaos. And so we had worked on that as well, so to make sure that, these motions, these appeals had, language that would help us, if we had to seek litigation. And then obviously the worst part was when, kids were, we got a notice that a kid might be removed, right? At that point, right, we wanted to ensure, that kind of give a warning, right, to, giving them the benefit of the doubt, letting them know, hey, under this, under the TV PRA, these children deserve to have, to be placed in kid-friendly proceedings, right, before they're being removed. And then really just waiting to see what they would say. Yeah.
Thank you for that. Gian, I want to pull you into this because these two cases are different, right? So with ImmDef versus DHS, it's an APA claim, and we had the benefit of consulting with litigators as we were working on these issues. But the case you and I worked on in 2019, which is Garcia Ramirez versus the ICE, is different in the sense that I did not have the benefit, and hindsight, right, to work with litigators while preparing these issues. So tell us a little bit. Oh, and this is also a class action case, which makes it different. So tell us a little bit about this case, and how is it that your organization at the time, what prompted you all to look for plaintiffs?
Thanks, Deanna. Yeah, so Garcia Ramirez v. ICE is a class action lawsuit that my colleagues and I litigated while I was at NIJC. And it challenged ICE's systematic detention of kids who turned 18 while they were in ICE custody. So basically, we started hearing that kids, upon their 18th birthday, were being detained. It didn't matter if they had a sponsor available or if there was potentially a post-18 facility that had agreed to take them. ICE was showing up on the day of their birthday and sometimes shackling them and taking them to ICE detention. So this caused a lot of dread, and kids were essentially terrified about their upcoming birthdays. And they really weren't prepared for how different ICE detention would be from ORR custody. There was no school, no free phone calls to their families. They were with people who were much older. Many of them felt unsafe. So we
limited access to counsel. I remember I couldn't even call my clients.
Yeah, it was hard to even figure out where kids were, and a lot of times they didn't understand why they were there, and they felt like they were being punished. And there was no way for them to call out because they didn't have any money on their commissary, a lot of them. So we litigated this case, we took it to trial, and the DC District Court found that ICE was violating the TVPRA, which says that ICE shall consider placement in the least restrictive setting available, as well as alternatives to detention for kids who are aging out of ORR custody. And so since that decision, the government appealed it and then we settled. So through the settlement, we've been receiving monthly data showing detention rates and basically the evidence that the government is basing all of their age out custody decisions on. And so since the decision, fortunately, we're seeing that 99% of kids aging out are being released. So it's a big change, but I'll bring it all the way back to how the case started, which was basically that our policy director at NIJC had heard that kids were being detained. Interestingly enough, we weren't seeing this issue in Chicago. So if we had just kind of not like put our ear to the ground and figured out what was going on nationwide, I don't think we would have been able to bring this case because it just wasn't an issue we were seeing locally. But so we put out some feelers. We were trying to figure out what was going on nationwide. We started looking for plaintiffs and trying to hear stories of what was happening to kids. We posted on a lot of listservs asking people to describe what they were seeing, if this had happened to their clients. And that's how we got connected. Well, obviously we knew each other from before, but this is how you got connected into this case. So if you want to tell us a little bit about the client that you brought to us.
Yeah, for me, this is definitely a hindsight because I was leading a detention team, right? So I had my head in the weeds, if you will, not looking up, not part of the listservs, not reading the listservs, if you will. I kind of just had the immediate needs of my clients, and that was what was most pressing. At the time, ISIS also didn't have a litigation department, so no one to really pull on or help widen our gaze. So it started out of our Corpus Christi office. When a kid was going to age out, we would collaborate with ORR on a request for release on recognizance. And initially we're like, okay, well, identify if there's relief. We do a relief determination letter, automatic detention. We're like, okay, that didn't work. What else can we do to be proactive to preserve our clients' rights? So then we started filing for relief along with, right, the OREC collaboration. Relief pending, not enough. Okay, what else can we do now? Okay, we had one client who we found T eligible, and so we made sure to get an OTIP letter saying, hey, the federal government, Department of Health and Human Services has designated this individual as a victim of a severe form of trafficking. Surely that and the pending relief, that should be enough, plus the OREC request ORR is preparing. It was not. All right, what else can we try? At that time, floor responds were becoming part of the practice. So we said, this isn't a secured facility, but integral to the floor respond is this idea that the individual is not a flight risk, not a danger to self or others. So surely a judge finding an ORR consenting to these facts should be persuasive to ICE and the OREC. We got floor responds. We were wrong. That is not something that ICE considered when deciding whether or not to detain the individual on their 18th birthday. Okay, relief relief letter? No. Relief pending? No. Floor respond? No. So another deck we had to play was administrative closure. Okay, administrative closure shows that DHS, right, OPLA, and that the immigration, EOIR, do not consider this case a priority for removal. If we can get administrative closure, surely that will demonstrate to ICE that this individual does not warrant detention on their 18th birthday. Wrong again. And so taking all these advocacy steps, in writing in the immigration system was one facet. The other was being a gagfly, calling the ICE officer, emailing the FOJC, asking to speak to the supervisor, and making sure to document these statements into we use e-immigration, so e-immigration call logs. And then at that point, when that still wasn't working, I hit a wall and went to the media. I didn't know what else to do because I was not yet informed on litigation matters. And so we decided, let's go to the media, because maybe if we do a public outcry, people will reach out to ICE. We can call on Congress to kind of our congressional representative to help support in this situation. So went to the media, and I guess that is how you all got word, and that is how you all reached out to us. So I think that was critical in exhausting the immigration field, but also in using the advocacy with ICE, documenting those statements to show there's a pattern, that there's a per se policy that shouldn't be in place. I didn't know, right? I wasn't necessarily thinking of it in the TVPRA context of least restrictive means. I didn't have that in the back of my head as this is the policy being violated. I just had that gut check, like this is outlandish, this is wrong. So what else can I do? All right, yes, I lost myself for a second. Thank you. So it kind of like in going through this and Gianna, to stop at where we were, NIJC reaches out because of the media inquiry. They pulled me in, right? And Yvette, you and I with ImmDef, we were collaborating kind of from the onset. But for individuals that don't have litigation in place, or even if they do in their department, what is the best way for them to reach out to litigators?
Yeah, I think I've seen this kind of from both sides, having worked at NIJC, similar to Raisa's, where we did have our in-house litigation team. So issues kind of percolated up, and we were able to see them coming in from our direct services team. But now at the American Immigration Council, we don't have a direct services component. So I think now we're always kind of putting our ear to the ground, trying to figure out what trends are out there, what's going on. Like we like to attend coalition calls regularly. We're looking at all the listservs, and of course a lot of times folks just like refer cases to us. So they're saying like, hey, we're seeing this really weird issue, like we think it's happening in other places, like what do you think about that? So I think really like staying in touch with litigators that you know, and then participating in listservs and coalition calls is really critical, because there are organizations like AIC that don't have that direct services component but do have the ability to litigate and are just on the lookout for issues.
Thanks, Gianna. Gardner, I know part of your fellowship role was helping the different units bridge that divide, but also you also build some relationships with other local organizations that do litigation. Can you tell us a little bit about that experience?
Sure. I'll take an opportunity to share what not to do in this case. We were working on an issue that came from one of these attorney roundtables, right, where I was meeting with attorneys and saying like, what issues are y'all seeing? And I kept hearing my clients, after they're being released from OR custody, are having a really hard time getting enrolled in public school. They're just either told you're 18, so I can't put you in 9th grade or 10th grade, what your grade level is. And anyway, lots of obstacles there. So I talked to Yvette and we started thinking, well, who's litigating like education and access issues in the area? We thought of our partner organizations that might be doing that kind of thing, and we pulled in a former or an acquaintance of Yvette's, a friend of Yvette's who's doing that kind of work. And so part of it is just like that good old-fashioned networking, you know, staying in touch with your law school folks or stay in touch with, you know, people you've worked with previously. But yeah, getting back to the what not to do, we pulled in this other litigator and they said, okay, we're really interested in hearing more about this. Can we meet with some of your clients? And I said, yes, for sure. And I'm really eager, you know, to build this relationship for us. And so I set up a meeting with one of my clients and this other litigator, and really quickly realized that I should have done more background and more homework on it, because this client and their sponsor had actually not done necessarily their due diligence in trying everything they could have to get enrolled in school, which meant I also had not done all of my due diligence to make sure that they, you know, were the right people, or at least were ready to talk to this litigator about potentially, you know, pursuing something through the courts. And so I guess that's just one thing to keep in mind. Yeah, so going back, yeah, network, keep in touch with your people. And then also, as you are trying to build these relationships, make sure that you are, going back to what I was saying before, make sure you have somewhere to centralize and track and really lay out the data, right, from the previous efforts that have been made to find solutions, because otherwise you might feel really silly and embarrassed like I did in that instance.
Regardless of you feeling silly, I want to pause right here and really highlight, especially to all our frontliners and our weavers, the issue that you're highlighting right now is not an immigration benefits issue, right? This is an access to education issue. And so I think this is a component where our social team, right, and our legal assistants really come together with us, because they can identify these other violations. Maybe it's not always that we have to keep in our forehead DHS, OPLA, ICE, right? USCIS. We're not always fighting them, but other systems in place that negatively impact these children, it's so critical that we identify and elevate those issues up. So I think props to the team and to you, Gardner, for trying to give them access to that, right? Even though I know you're sharing the example where it was a lesson learned. So that's with other, if you have a department within your organization, what is a good way to bridge that department divide?
Yvette, do you want to speak to that one? Because you also have worked on both sides of this bridge, so to speak, within Raíces as a children's program attorney first before joining the litigation team.
Yeah, I think, right, my perspective always comes as an immigration practitioner first. I tell everybody I'm a children's program attorney first and everything else, right, later. But really, it's really understanding our roles, right? Understanding, again, our staff doing the work on the ground are the experts, really giving them that time, figuring out how our team can be helpful to them, right? I think for the most part, we don't see as many clients, right, as I used to when I was an immigration practitioner, but it's really now taking the mindset that, I provide services to my colleagues, right? Our immigration practitioners. What can I do to make their life better? And really, I think it's really that respect that we have for each other, right? Really, giving them a space, and please don't ever feel, feel like, you're unsure if, you should have this conversation with the litigator because you have no idea, right, about litigation. I think that, your contribution is so important and so critical. And it's really understanding our different roles.
Thank you, Yvette. Okay, so we check in with our team. We realize an issue that's happening is not just for this case. We do everything we can to advocate for the right outcome, and the system is failing. We make the referral. What should we expect? And when I say we, I don't mean us, just the attorneys or BIA accredited representatives, but also our social service staff. When they identify and elevate, what should we expect? What happens next? I'll turn it over to you, Gianna.
Thanks, Deanna. Yeah, so I think once we get a referral on the litigation end of things, so usually if it's a class action case that we're trying to bring, we would have developed like a plaintiff profile describing the kind of facts that we're looking for, so things that the client has experienced. So we would review the referral, anything included in it, and just confirm that the facts match what we're looking for. Then we would typically schedule a meeting with the child, and the immigration attorney is usually welcome to be there. And a lot of times we know that will provide comfort to the child. So that's really great. But we'll discuss what the lawsuit is about with the child. We'll explain the goals of litigation, explain their rights as a plaintiff, and also their responsibilities, like the fact that they might be called for a deposition or for testimony later on, but we try to make sure they understand that we're there, we're going to be their attorney, we're going to make sure they're fully prepared, and we're going to be there to represent them if that happens. Then we would sign a retainer with them, and then usually work on a declaration with them explaining what issue happened in their own words. And that declaration would be submitted with the initial legal filings at the start of the case. So usually a complaint is filed, and then likely a motion for preliminary injunction that'll include all the plaintiff declarations.
That kind of pulls me to my next question, Gianna. What role is the legal immigration attorney or advocate playing here? Are they at that retainer meeting? Do they review that affidavit that you're preparing? If you, and then of course Yvette with your experience can kind of walk us through that.
Yeah, I mean, I think it depends on the litigator. Coming from this space, I really welcome the participation of the immigration attorney, and I think it's really crucial. And I think it's really helpful in us as the litigators making that connection, especially if the plaintiff is a child. And so I think the role of the immigration attorney is so critical in these cases. And a lot of litigators may not be looking at the case from the same perspective as you. They may be looking at the litigation only. So they're not thinking about, how could presenting this information information potentially harm this plaintiff in their immigration case? Am I presenting conflicting information about the child's asylum claim? And that's why it's so critical for the immigration attorney to be there, to ask to review the documents, to make sure nothing is being submitted that could potentially harm your client, or maybe too much information is being included about the child's claim and that's not really relevant to the type of case that's being brought. And you think maybe that could damage the child's asylum claim later on. Can we remove that? I think all those conversations are so important to have. And I think really I want the immigration attorney to be empowered and make those calls for their client and for the benefit of their client's case.
Gianna, for Garcia Ramirez, it felt a little backwards to me in that class action, in the sense that I had already done all the work and you all had already done all the work when I came into the case. So I think in that situation, my role was a little bit different than maybe what you normally encounter. But I definitely had to work closely with you and your colleagues on understanding what the case was about, what you needed, and then going back to my clients and kind of getting that consent to share the evidence, right? Because my clients were potential class action members when it all started, but they weren't clients that you all had retained yet. So I think in that situation, the role was having this open dialogue, getting a better understanding of the class action case, and then going back and being that bridge to the client, communicating that to my clients and getting their consent to share their story, share copies of their filings redacted, share copies of those communications with ICE. And then oh, sorry, go ahead, Gianna.
No, go
please.
ahead. Sorry.
And then I know that at some point you were asking, and not just me, but other immigration attorneys to write affidavits themselves. Can you tell us a little bit more about that?
Yeah, that's exactly what I was going to say. I think in your situation, it was different because your clients didn't end up being plaintiffs, but we ended up relying on all of your meticulous notes and all the information that you had gathered through the course of your representation of those clients in a declaration from you. And so that was different in that you were protecting your client's interests and confidentiality, but we didn't share a client in that situation. We were putting forth the evidence that you had collected to the court, and then you were deposed actually through the case, and we ended up playing your testimony before the judge, which I think was so important to the judge understanding what was going on locally.
So the role can be getting that feedback for the client's affidavit for litigation matters, but it can also be the attorney writing their own, possibly going to court. What role in the trial or court testimony, I guess, what is the role of the advocate when your client and the litigator's client is going to go to court, or when the attorney themselves has to go to court? What does that look like?
Yeah, and I'll let Yvette chime in too if she has anything to add. But yeah, I think if your client is also our plaintiff, and for example, if your client is being deposed or is going to provide testimony at trial, I would ask as the immigration attorney to be there for prep, to ask, like, what is my client going to be asked? Usually as the litigator, you're going to have an outline of everything that you're going to ask. You can't predict what the other side, what the government's going to ask, but you can kind of have an idea. And we do practice cross, and so we can definitely prepare clients for that. And I think with the help of the immigration attorney, it's really helpful to know, like, hey, I'd really like to stay away from X, Y, and Z related to their claim, or I'd really like her to not share this. And as long as it's not relevant to the claims we're bringing, we can definitely be respectful of that. And we think that's so crucial because we're just looking at the issue from different ways.
Yeah, Yvette, if you could chime in on the ImmDef versus DHS, because I know that there were affidavits that had to be filed, and definitely communications that the immigration attorney had to have with the client. So tell us about your experience. And we do have 10 minutes, team.
Yeah, I think, initially we had shared a lot of, the documents. And then once, we were getting ready to file, it's really ensuring, can I review those documents to ensure that all the redactions, all the redactions had been put in place, right? And so it's really, let me be a second set of eyes, right? It doesn't hurt. I think as litigators, we will welcome that as well. And then, I think, when it came to affidavits, it's really ensuring who was the best person who could be the declarant, and figuring out, right, we wanted to ensure that, it wasn't very, at least in the ImmDef case, right, it was a lot, if we were there we served as an organizational plaintiff, right? So it was really focused on the harm and the to the organization that this policy created. And so really figuring out who was the best person in our organization to write that declaration. Obviously, Diana became our main witness in trial because she really, she supervised all the attorneys who were working with kids who were being removed under MPP. So really it's figuring out who is the right person to write that declaration. And also in some way it helped us because Diana had a very broad knowledge of the issue. So if they asked her questions that are super in detail, she couldn't answer that, right? Because she wasn't the immigration attorney. She didn't have to go into the asylum issues or SIJ issues, right? She was mainly there to testify about, the harm to the organization and what Raíces had, what kind of new policies they had to put in place just to survive that period of time.
I think that's kind of key for the legal advocate's role, because I remember when we were working on Garcia Ramirez and on ImmDef, there was this idea of like, oh my goodness, I have to relitigate this immigration relief or this motion in a completely new and different avenue, and one in which I am not well versed, but not at all, right? And I think that there were definitive decisions made, strategic decisions made on why we're not going to include evidence of relief eligibility in some of these cases, because relief or no relief, that's not pertinent to the government violating this policy or law. And so I think rephrasing it in the sense of the role is not necessarily of the attorney to make sure the voice of the relief comes in, but just to protect it. And to that, I kind of want to ask if any of you have had a situation in which you started the process, but then for some reason or another, maybe the immigration relief component, you kind of had to hit the brakes on the litigation case. Gardner, I know you had a situation like this.
Yeah, I can share. So this was one where we were working on we had already done the SF-95, which if you remember is the administrative sort of pre-component to the Federal Tort Claims Act complaint. So Yvette and I were in the process of drafting the complaint. And this was a client who was wrongfully removed under Title 42 and exposed to the trauma of being sent back to her home country where she had fled and was seeking asylum. So it was, a really traumatic story and someone that we really felt like deserved justice in the form of damages because she'd been subjected to a huge harm at the hands of the government. But as we got into the facts in our drafting of the complaint, we realized that if we, really had to lay everything out, that it was going to call attention to some of our clients' conduct that could expose her to charges. And so unfortunately that was one where we had to step away from it. But that goes back to, what is the immigration attorney's role? It's to protect the client and one of the roles, right, is to protect the client and the immigration relief.
And Gianna, I don't know if you, oh, sorry, go ahead, Yvette, please.
I was just going to share, recently our litigation team was looking at a habeas issue for prolonged detention. And, we had gotten really close to, completing our research, and then learned that, our client, I guess he was going to be removed and then decided not to get on the plane. And so for prolonged detention, right, the prolonged detention cannot be, or a part of it, the plaintiff cannot be in some way at fault for that prolonged detention. And so the fact that our client had, decided or chosen not to get on the plane really just ended our research there, right? There was nothing that we can do because at this point it was our client who was interfering with his release.
No. Gianna, I was going to ask you if there were because we just heard from situations where, right, the immigration attorney kind of had to pull the brakes, but have there been situations where after the retainer signed, can the client, if they don't want to go forward, stop? Or if all of a sudden the client is feeling very hesitant or scared of the system, how has the immigration attorney come in to help support the action, doing away with some maybe preconceived notions of corruption in the U.S. immigration system and government system?
Yeah, that's a really good question. It's definitely something that we've seen. I remember in Garcia Ramirez and also other cases where we might be looking for a plaintiff, and we receive a referral and we're like, oh, this is great. They look perfect on paper. The facts are everything we're looking for, but we meet with the person and it's clear, you know, they don't want to participate. They're answering with maybe like one-word answers. And we think like often it comes down to trauma, and like we really don't want to re-traumatize someone, especially a child, through the legal process. And we know that the legal system is not the most trauma informed. So it's something that we want to be especially mindful of when we're putting someone in the position where in a class action, they're representing a whole class of individuals. It's a lot of responsibility, especially for a child. So maybe that person is not right to be a plaintiff. And we want to be mindful of that. But if it's a class action, they can still benefit as a class member. Or maybe there's a different way to tell their story, perhaps through an attorney declaration like you and Yvette were discussing. So maybe there's other ways to put their information in front of the judge that isn't going to be re-traumatizing or do something that they don't feel comfortable doing. And I think the immigration attorney in this kind of situation can play such a critical role because you know your client best. If you think your client maybe is shyer, is not going to want to speak up, is really hesitant to talk to new people, let us know that. And we may still want to talk to them, but we will be mindful of that and maybe think through other ways and more creative ways that we can bring their facts in front of the court that don't involve putting them in the situation that they may not feel comfortable with.
Thank you for that, Gianna. We have about 3 minutes left. So I did want to open it up to any closing remarks from our panel and then any possible questions. I see one question here. How are you overcoming 8 USC 1252 in ImmDef versus DHS, assuming that's an issue?
Can you repeat the question? I'll read the chat.
Yes. How are you overcoming 8 USC 1252 in ImmDef versus DHS, assuming that's an issue? And that might be a longer conversation than the 2 minutes, but we can definitely try and reach out and try and have a call with this individual. It's Jacob.
Yeah, and so I correct me if I'm wrong, it's the judicial review of orders of removal, correct? And so a lot, like I said, we were serving as organizational plaintiff. We weren't, we weren't serving, there wasn't a client, right? There was no removal order. It was really based on how this policy was harming our organization. So we didn't really have to even address it. It wasn't about the removal order. It's about this a policy and and how it was unlawfully applied to UCs. And like I said, sometimes they didn't even have a removal order, right? A lot of times they also were in removal proceedings under MPP. So there was various ways how we sort of got away from that issue.
Thank you, Yvette. We have about 30 seconds left for anyone else. Oh, any advice for attorneys who might be intimidated to incorporate the litigation aspect into your work? With 1 minute left.
I can say something. I'm one of those. I'm still a baby attorney, and so I feel intimidated too. But just pull people in. Like there are more experienced folks out there who can guide you and mentor you. And if you're worried that, oh, I don't want to like go up to the circuit court and mess up the precedent, I feel you. That freaks me out too, right? But find mentors and get on the listservs, and there's a whole community here as evidenced by everyone who's on this symposium call today. So we can do it together, I guess, is the answer.
And remember, you don't have to take on necessarily litigation matters. You can refer it out.
I also, even in my role, right, as finding mentors, I felt more comfortable reaching out to litigators who had an immigration background, right? Because, you know, we spoke the same language. And so there's a lot of, you know, I want to encourage also, right, every immigration attorney, you can do litigation, right? There's a lot of folks that are out there doing it, right? A lot from NIJC. But yes, I think that for me, that was helpful because they spoke my language.
Oh, there's something I want to mention, and I know we're at time, is if you are going to take the step and be the immigration attorney that might get deposed or have to go to trial where you may get cross-examined, be wary of your social media posts because they may come at you with it, which was the situation in my case where Twitter at the time, I definitely got cross-examined on some of my posts.